Welcome. This is the Domain Name Law Show. We're here every Tuesday, normally noon Pacific, 3 p.m. Eastern. Today we're broadcasting 3 p.m. Pacific, 6 p.m. Eastern. Jeff and I are unable to be here for the entire show, so David is going to take it over from here. David, are you there?
Yeah.
Fantastic. We were on a break from the
welcome,
deposition,
everyone.
so I'm going to jump off,
Arif,
but
if
we
you're
got it rolling.
interested-
Thank you so much, David. Have a great show.
Can you hear me?
Yes.
Is my audio coming through?
Yes,
Okay,
and
great.
I'm
Arif,
on.
do you want to
Make sure
join
this
as a
is streaming.
co-host? That way, keep the conversation going.
Yes, I'm going to keep the conversation going. I'm going to go on mute.
Yeah, Arif, do you want to join?
No. Let me invite Arif up there. David, I'm going to invite you to co-host. Oh, you already are co-host. That way you can invite Anthony if he wants to join.
Hey guys.
All right, have a great show.
Give me 2 minutes. I'm just gonna get just putting my headphones on and go. I was going out for a walk to listen to you guys, but I'm gonna give me 2 minutes. But I'm here though.
Wonderful. So welcome, everyone. So it's Domain Law Show number 264. And how many years is that? It's a lot. It's more than 5 years, I think. Anyway, so today we have a decent show. The first thing in the newscast is Network Solutions gets duped by a fake UDRP notice. And apparently somebody spoofed the forum, their forum email, and sent a suspension notice to Network Solutions. And then John Bearhill reached out to them and say, hey, who is, like, what's the case? Do you have any details? And no, but the forum is the provider. And I guess they confirmed that there is no such case. So yeah, that's the second time I've seen this. Before, I think it was last month where it happened through name.com. And that is a problem because if our names get suspended while we're operating a business, or anybody gets their name suspended operating a business, this is a major vulnerability for any big business. So I'm glad that that's, at least this one was figured out soon enough. Arif, have you seen these things happen before also?
Yeah, I mean, this is I heard it about twice before, and like recently, right? And you guys have discussed it, and so this would be like the third I think I've heard of recently, and it's really bad because it's like it's a security issue, but integrity issue, and it's like, it just goes to show that the registrars aren't, like, there's no system in place where it's checks and balances, like a solid system where you have to go to certain protocols. Like, there are times when they tell us, oh, we can't do this, we can't do that because of legal compliance, blah blah blah, but then they do this, right? And this is obviously, they're responding to people who aren't even customers, right? Like, for, again, I don't, whatever, I don't even use GoDaddy, like any registrar per se, right? Like, it's been a customer for like 5 years, and I've got something that, okay, it's a little bit borderline, you need them to, let's say, make an exception to the 60-day or whatever it is, 6-day lock, like, well, we can't do it because of compliance, right? Or because of the things. Well, okay, fine, but you know who I am. I've been a client for like 5 years, right? Whereas this is like 100 times worse, and it's not even a client, right? Like, I mean, you need to be able to verify these things. I would think they're, at the very minimum, ICANN should put in some sort of central registry of, semi-legitimate legal entities where those emails, like, are a central list that's authorized by ICANN, that the registrars can consult and go, okay, this request is coming from this email. Okay, we can consider it. Now, beyond that, they also have to consider the reality of the request, right? Sometimes people say that there's claims of misuse or whatever it is, and sometimes it's true and sometimes it's not, and sometimes there's evidence and sometimes there's not that much evidence and hearsay. But for them to just willy-nilly accept something from a total stranger without any further sort of evidence, it's just it's horrible. It's like, it's really bad.
Yeah, absolutely. All right. So the next item is, well, we have a frequent flyer with the UDRP filings, and that is Coachella. They filed a UDRP complaint against Coachella.com and Coachella.org. What do you think about those names, RF? Could they be like an online digital music brand or an edgy brand that's counterculture by some other type of entities? It's
Did you
actually
say? Did you say CUNT, Chella?
yes, yes. In fact, you can trademark these kind of vulgar words these days because of a decision at the USPTO a couple of years ago. So now they are legitimate fair game for getting trademarks on them.
Yeah.
And this lawyer out of Buffalo decided to register these two names. She actually runs an online music thing called Realize Music. It's a VR music system. And she's an IP lawyer. Oddly enough, she did not respond to the UDRP complaint that was filed by Coachella.
Wow.
And you know what happens when you don't respond? Coachella wins.
Well, yeah, it shouldn't be necessarily automatic. The big question I would have, because like, there's a lot of times when it's gray zone. It's like, okay, well, what, like the suffix Chella, is that something that's commonly used or not? Like that would be
It is.
actually.
It's used by 3 other brands, so it's not just Coachella that's using it. It's used by 3 other brands. There's a t-shirt company, there is a cosmetics company using it, and also, Cella is a dictionary word in Europe. It means bee, so like a buzzing bee, bumblebee or something.
Hmm.
So, it's a dictionary word. It should be fair game, and I don't think they should have a claim over anybody using that or any kind of name that's resembling it. What do you think?
Um, this is one where the context really matters. Like what was on the page? What was the business being used for? Or was it just like a blank park page?
It was
Um,
not even a blank park page. It was a registrar parking page with no ads, just saying server setup. And I believe this is the registrar out of Louisiana that some people use. I think she was using CWASP or let's check. It
she
is
wasn't a game investor, was she?
no, she's a lawyer, IP lawyer, and she's in the music business. She's using DirectNick.
Because like if I'm sitting there as a panelist, I'm asking myself like, what possibly could they use this name for, right? I mean, with a CUNT, it's like, you could argue saying, well, I can use it for business, but really, is that like a is that a reality that anybody would use that as a business name, right? As opposed to targeting Coachella, which is a possibility which you could do, right? Like you can have let's say you had a bad experience at Coachella, and you wanted to talk about it, that would be a great domain to use for it, right? But then you have to say that's your intent. Like if you don't reply to UDRP, then that's the panelists can't assume that. But it could be a justified excuse for the second part of a UDRP, right? Stating that. So, the fact that she didn't reply might have hurt her in this case, but depending on what her intention was.
Yeah, and there's also a different brand register in the USPTO called anti-cunt, as in like, your aunt. I think that's something that maybe Jamaicans might use, although this IP lawyer is not Jamaican, she's white. So I think there is a cultural feminist view where they use that word.
Well, I
And
mean, I can't know if it's in UK and or in Australia, where it's more like, it's almost used like interchangeably with like buddy type of thing. It's like it's a slang, but it's like, it's so far fetched that it's actually not meant in a negative way, right? Not in North America, but I know I can't remember if it's UK or Australia. I know in one of those two countries where they use it the word like as a like between close friends where you're kind of like, a half insulting, but in a loving way type of thing, it's just, but again, like with the Cella part, it becomes quite distinctive. Like Coachella is extremely distinctive. So, it starts with C. So this is a borderline case where I think if the respondent had have given almost any excuse, it would have been almost, justifiable, or very hard for the panelists to justify going against the respondent if there had been any, even half-baked sort of reasoning for holding the main. But if you're not going to reply, I know Todd often says, this is where it can hurt you sometimes. It shouldn't in many cases, but the panelists can't just assume, some sort of usage when, it's Coachella is pretty distinctive. And this is, again, when I ask how many other Chella suffix businesses there are out there, if there's only 3, including Coachella, it's not a huge number, but it's also not zero, right? So again, this is one of those ones where it's a gray zone, and I think a response would have really helped. I didn't read the decision, but I can just assume that.
It was a transfer. But we've discussed other Coachella cases in the past, and I've uncovered that Coachella is actually down near Indio, California, and there are a lot of festivals going on there, but there are a lot of other brands and companies using the name Coachella in their company names, from fruit suppliers, farmers, markets. There's a whole bunch of businesses using the term Coachella, so it's not a unique name. And so why should anybody own Chella, which is actually a dictionary word?
Yeah, and also, but Coachella is a location. Then again, they could use it as a brand in some contexts, because it's not like Coachella Music Festival would almost be less allowed, because it's like a geo plus something else. But just Coachella on its own, they could use it as a brand, and if somebody did something else in Coachella, they wouldn't be able to argue too much. But anywhere else in the world, they could argue it. But again, this is a variation, right? So it's CUNT Chella, and I don't know, man. It's just if she had replied, I think there was a lot of ways she could have justified it. But what did the decision get into any specifications of the reasoning? Oh, David? Oh, I think we lost David. All right, I guess I'm now doing
I'm here. Okay. Sorry. Yeah, the decision actually was a transfer, but the thing was, the panelist he was a judge out of Colorado, I believe, or a retired judge. And he said there's no possible way that this name could be used. And he cited Nuclear Marshmallow's decision. And that is a wrong application of this rule, because there are conceivable uses of it. And just because you haven't developed a website yet is not evidence of bad faith. So that, I think, was an erroneous decision on that basis.
Yeah, Nuclear Marshmallows, I think, is a case that's often miscited, as it's passive, passive holding is automatically sort of bad faith. No, it's not. Like Nuclear Marshmallows, I think there was 5. I forget exactly what they were, but there was 5 distinct reasons that the panelists came to that finding. It wasn't just willy-nilly, passive holding. It was there was specific reasonings. If I could find that, I forget now exactly what they were, but let's see, Marshmallow. Glasses. Glasses on. Yeah, there's 5 reasonings. You need my glasses on. I'll read them off, because this is an interesting and important case. And often, the passive usage is really seen as a negative, but it's really specific. So this Nuclear Marshmallow. So the first reason was the complainant's trademark had a strong reputation and is widely known, as evidenced by its substantial use in Australia. So basically, Nuclear Marshmallows, the domain in question was what is it called? It was no, it's not Tesla. Telstra. Telstra was the domain. Telstra, I think it was Telstra, might have been .org or something like that. And Telstra, especially at the time, 25 years ago, was basically the largest company in Australia. It was their telecom company, right? So it wasn't it was an unknown thing. So reputation was the first one. Then number 2 here was respondent has provided no evidence whatsoever of any actual contemplated good faith use by the domain name. So again, the Nuclear Marshmallows was the name of the company holding it, but they didn't respond. So again, like in this case, like the panel is just left guessing, right? And this is the one type of situation where as a respondent, it really helps that you do respond, because the panel can't just blindly assume usage. And the third thing is the respondent has taken active steps to conceal the true identities by operating under a name that is not the registered business name. So because they used a fake who is information, that was one good reason that the panel found against Nuclear Marshmallows, the company, right? Because it didn't exist, the company. So that's a big factor. And then, so there's false.
The last part is no plausible good faith use.
Yeah.
And that's in the opinion of the panelist. But given that there are other users of the term chala, there is a plausible use for it. And and if it was just used like as a pejorative way, like say like walmartsucks.com, and those kind of decisions are always like denied because it's free speech.
Yeah, but usually there's content on the website that would, like in this case, like talk against Walmart, right? So in this case, there's no content, or it's just a generic parking page by the registrar. So there's no indication of any sort of criticism site that would be there. And again, like all the respondent would need to do is say that, oh yeah, they had a bad experience, and they'd probably have to prove the bad experience if there's no content. But it's a justifiable excuse if you can back it up. Now again, if you don't reply, it's panel can't take it for granted, unfortunately, as much as we'd like that to happen.
Yeah, and in this case, the lawyer could have said, well, I run a music business, on an online music business, and this is my this is my target market, and it resonates with them, so that is the purpose of it. Even though it's not built out yet, my music business has been going on for 2 years. So that in itself would show preparation of use.
Yeah, but you have to show that. And again, like it probably would be kind of allowable, because I don't know if Coachella is just the concert aspect or the festival aspect, and they don't deal in music as well, right? Sometimes these concerts, what they also do is they'll also like sell CDs and other sort of music, in which case there might be an argument for what you're saying. Again, I don't know what type of music business she wants to do, right? That's again, she needs to state that.
Yeah. You have to respond to these complaints. Now, she could still sue in federal court under the ACPA and get this case nullified, basically, and just try to get a judgment in federal court. So she is a trained attorney, but the domain is actually registered to her law firm. So I don't know how that would work, but it's an LLP. So I guess you can in the US represent your own law firm. In Canada, you cannot, which is weird. But yeah. So that's the first case.
That's actually strange, because like if it's registered to the law firm, then wouldn't the argument she have to make is like she needs to use it within the context of the law firm? Or is that
that could be, but the question is, do the federal courts allow, like, I know if you have a LLC and you're not a non-lawyer, you cannot represent your LLC in the US. But if it's an LLP, I guess that's just a partnership. So yes, you could represent the partnership because it's not a corporate entity. And so she would be able to represent the partnership, even in Canada. But
that I get. But what I'm saying is, like, if the domain name is registered by her lawyer company, by her company, that's the law firm. That's kind of weird, right? That's because, like, you're saying, oh well, now my law firm is going to do music. Well, it's kind of like
not necessarily. So, for example, I have like a registrar account, like say with Spaceship or wherever, and I register a new domain name. The WHOIS information is the same across all of my domains unless I update it specifically for some domains. So if I register a domain name for a client, I have to proactively go into the WHOIS records and change them to put my client's name there, even though it's in my registrar account, because I don't want, I don't want to be named in any UDRP complaint against that domain. But yeah, I should always have the client name there. So it could be one of her clients. She could be holding in trust.
Well, maybe. But then in that case, she really should have responded.
Yeah, because these UDRP complaints are a bad mark against you, and you don't want to have too many of them. And that is a problem. People don't respond. And I think it's because either they don't know how, or it's too complicated, or you're busy. But you know what? Now with AI tools, it's going to get a lot more cost effective to respond. I'm building a tool at udrpai.com, and hopefully it'll be ready soon. And at least it'll give you an outline for a response. It's not going to be the final word. You're still going to need a lawyer to review it and massage it, but it's going to do all the background work that I usually do when I prepare for these shows. And that's going to be enabled by this new agentic technology. So it can do the trademark searches, which is a huge deal to have an LLM do a trademark search, because normally you cannot do that. They try, but they miss out a lot.
Well, that's cool. I mean, like what you guys do like every Tuesday here, man, it's really impressive. All the information, especially that you gather, like for when you talk about each of the cases, it's impressive. It's not very easy at all, you know?
Yeah, well, it used to take me like an hour per case, and now I can do 4 cases in an hour. So that's a huge time crunch. So in our next case, it's legal-now.com. And guess who the complainant is? The owner of legalnow.com. So I know people always put down these hyphenated names, but this one was on the drop, and it was acquired by a guy in BC, Stephen Lowry, and he decided to launch his own legal helps website on there, and that would actually help people team up or find the right lawyer for their case. So that just got started recently. He just filed a Canadian trademark application after receiving the UDRP complaint, which usually is not sufficient. Usually you should do it before the complaint is received. But in this case, the complainant is based in the US, and they were not able to prove Canadian trademark rights. So this is a case where there are 3 panelists, and they said, well, this is not the kind of case that should go to a UDRP, because it's complicated and there's multiple jurisdictions. And is it really a trademark? Do they really have trademark rights everywhere? How well known is it in Canada? Do they have any usage in Canada? And they did not respond. So when the panelists didn't get a response, they just, okay, we're going to deny this complaint without prejudice. They can go to court if they want. What do you think about that?
In the overall sense, it's really tough. The URP, like, we hear about these cases all the time, right? And your knowledge about it, Todd is, and Jeff, but the thing is, the average person, even myself, like the average, like, it's just overwhelming, like the whole process. Like, you have to prove things, but you don't, like, once you've probably gone through like 20 UDRPs or maybe even 10 UDRPs, like, you kind of know what the back end process is, and expectations, and okay, you'll hear, you'll get a good like pulse on what to expect as results. But if you've never gone through one before, right, you're fumbling. You're going to fumble through it because you don't know, okay, how much energy and time do you have to put into each argument, right? Is it like you put 3 sentences and the panel's going to understand it and you're going to win your case? Or is it like you have to put 30 pages of all kinds of stuff with 20 citations and all? It's like somebody who's never gone through it before just doesn't know. So as you're going back to the beginning of the show, what you're talking about, yeah, I think a lot of times people don't respond because it's so overwhelming, right? And then, in the cases where you're operating as a business, well, then it's an easier reply because you're operating as a business. But if you're like somebody like, us who are like domain investors, it's like, well, what do you do? And in most of those cases, like for us, the domains in question, typically are not worth all that sort of legal sort of help. It's going to cost you 5 figures oftentimes in just legal fees, right? And like you ask yourself, well, for like $10,000, like I could just buy a different domain that's probably a lot better, right? So at that point, it's like that's what sucks about the UDRP is that like there is a challenging obstacle in terms of knowledge that prevents, I think, what I would call like total fairness, right? There's obviously the complainant side usually has significant legal representation who, first of all, they have the time and they're getting paid for it, but they have the experience, right? They just use citations over and over again and they fill up the case, and then respondent is there. And it's like, well, I have to read all these citations. I have to understand them all. I have to ask legal questions. Like, I mean, for somebody like people here in the audience, where we've been given the gift of listening to the three of you guys, for the last 5 years, give examples and explanations and all that stuff, it's going to be a little bit easier. But for the average domain investor who doesn't even have even that preliminary basic knowledge, it's going to be almost impossible.
Yeah, absolutely. And even if you do respond, even if you have an idea as to how to respond, oftentimes when they think that you're acting smart, like you're a lawyer or something, that you should know all the cases that apply to UDRPs. But oftentimes most lawyers have no clue because it's not their practice area. They do trademarks maybe, but not domain name law. So it's quite different. So yeah, it is challenging. You do need help. You do need to have some sort of guidance and understand the format, what exactly is important. But let's go on to the next case. And the next case is actually quite interesting. So there's this company called Carfax, and they're quite popular. And their domain name is under owned by or covered by Mark Monitor for Carfax, and they own this other company that does account market. So it's accsmarket.com. And let's see what that one is. Is that the same one? Because I'm thinking this is the same Carfax. And if it is, this is going to be a big deal. So no, they're using a different registrar, but it's a different registrar. So maybe it's a different owner. But this company is called Carfax Commerce, and they own accsmarket.com, and they filed a complaint against accs-market.com. And you think, well, why would you do that? Well, because the person who got the name was apparently ACCS Market stands for accounts, and they sell Facebook accounts really cheap and in bulk. I mean, you can buy like 50 Facebook accounts for 15 cents each. And what do you think about that? That sounds like a criminal organization to me. And they're incorporated in the Seychelles, which is Russian-controlled territory. They do a lot of illicit banking there. So I think that, just on that alone, I would have refused the complaint. But the panelists said, you know what? This is not trademark infringement. They just got a trademark only in the Seychelles and nowhere else. And that was just recently. And the domain was registered years ago. So they denied the complaint on that basis. How would you have rolled on that, Arf?
Well, can you still hear me? I switched my headphones. I was going to step outside and go for a walk. I'll just talk. Can you hear me? Hello?
Yes.
Okay, good. Yeah, I mean, there's a lot of moving parts in this one. First of all, don't mess around too much with Vladimir Putin. But no, but as you're saying, like, ACCS markets, like originally, like that to me, it sounds very distinctive, and therefore, the respondent would really need to have really good justification to have such a sort of similar domain of something so unique. But when you say it stands for accounts, I mean, yeah, I could see that as being more generic in nature, right? And furthermore, like, it's like I've never heard of them before, right? So it's not as cut and dry as I think they would like it to be, because if they're only operating in one country, that again, like it, you really you really need to be globally known in these cases, or like if it's actual business, then in the country of the businesses, the other business is trying to operate in, and if it's a domain investor, well, then it's almost needs to be global in scope, right? Because as a domain investor, we're usually selling domains all around the world, right? That's my target market. I don't operate in .ca specifically because I want a global audience, right? A global potential market. So if they're only known in Seychelles, I don't know how to pronounce that, but anyways, it's it's gonna be tough to argue that one, I think. So I kind of maybe agree with that one.
Yeah. So that was
How did they have anything on that website? The respondents?
Yeah, so they were using it initially, and then they stopped and they transitioned and they forwarded the domain now to their other domain name, which is a little different. But if you go to ACCS-market, it'll get forwarded over. And they're selling YouTube accounts, but not for 15 cents. They're selling them for like thousands of dollars, which is more reasonable. Like I can buy Alpha Noob for $2,800. It's got 3.8 million
But
subscribers.
it's so here's the thing. It still is like very similar. Like I think the argument can be made that it's the same sort of type of business. So there could be conflict there, except that like when you're talking about that sort of business, you could argue that like account markets, which is the abbreviation for ACC, that's a generic term for it, right? So trademark, I don't think even would be justified to, or should not be allowed. Account markets, I don't know if that I consider generic or not for a marketplace that sells social media handles. It's a yeah, that's one of those ones where it's not so cut and dry.
I would say it's merely descriptive, if not generic. But you'd have to show significant notoriety to get a registration for that. That's kind of like LA Fitness. Initially, they would have been refused as geographically descriptive.
Yeah.
But they got on the supplemental register, and then they eventually got on the principal register after a number of years and having thousands of locations. So that kind of thing makes it famous. But
And this is totally different.
Sorry?
In this case, it's totally different. It's a very tiny company.
Yeah. And so this guy's new website domain is dealbaron.com, which sounds more legitimate. And he's not charging 15 cents for 50 Facebook accounts, which sounds to me like, hacked accounts that are sold to Russian trolls to impersonate Americans or Canadians or whomever. So
yeah. I like that Deal Baron. It's a good domain. Just
yeah. So let's see what the next case is. It's here's a good one, digitalseat.com. What do you think of that as a domain name? It was sold recently in a GoDaddy expired auction for $801. What does that tell you? Does that mean there's a lot of bidders on there or just a couple of bidders? I guess you couldn't really tell.
that's what the type of domain that at first you're like, it's like silly domain. And you think about it, it's like, yeah, there's a lot of potential uses on that, right? Like digital seats, like, it's quite generic, and it could be a lot of things, like some sort of application for almost anything. That price is a high, like, but I'm cheap, right? You guys know I'm super cheap when it comes to acquisition prices. What was it? What was the case on that one?
So it was a transfer, but here's where it gets quite complicated. The complaint was filed, and the owners of the trademark are not the complainants. They claim to have acquired the trademark rights through a auction through a bankruptcy court. And that's troubling because when you look up the file in 2023, the trademark registrant filed a security agreement with a third party who lent them money. So that obscures title to the trademark. And it cannot be granted by a federal court bankruptcy judge unless that security holder has notice and opportunity to respond to the bankruptcy. And so in this case, there is no mention of that transaction happening, or what whether or not the rights holder actually showed up in the bankruptcy case. And I couldn't find any notice of it in the court listener docket. So I think that this complainant actually tried to pull a fast one and got a domain name. It's interesting that the digital seat owner trademark registration that was registered by another company recently is actually only on the supplemental register. And what that means is it's not a trademark. It's a registration, but not a registered trademark. It gives you some rights, but not a regular trademark registration. And so that tells you that the name is merely descriptive. That's like the first step.
Yeah, see, this is exactly the type of thing I'm talking about. Like, if you're if you know the law very well, like you start off your response to this accusation, and you just right away the first part of the UDRP, it's already fails because it's not a real trademark, right? And so like you can't the trademark owner, or the not the trademark owner in this case, but the complainant in this case couldn't even continue. Like wouldn't be allowed to continue. Just like the panelists wouldn't even read the second and third part. They go, no, you don't have a qualifying trademark. This case is already dismissed, right? But again, the average respondent won't be knowledgeable in such things, right? I don't know if your tool will help people discover that sort of thing, but even then, most people wouldn't even know what to even look for.
Yeah, absolutely. Yeah. So yeah, my tool will, you know, flag any type of supplemental registrations, and that would definitely fall into the arguments. So yeah, like there's two parts to the tool. So one part is doing the search, and the second part is putting the information together and basically coming to some sort of logical argument. And Claude's very good at that. So I wouldn't, make my own AI. I would use Claude, but with my own database and agentic features. By the way, have you seen these agentic names sell recently, like agentic intelligence? What did that sell for? Was it 150,000?
Yeah, I think it was, a little bit, yeah, about that. That's crazy.
Yeah, and I saw female intelligence sell um, yesterday for
What did
what
that
was
sell
that?
for?
15,000.
Okay, that price is a little bit more. Yeah, that I get. I mean, the agentic it's huge, right? And any startup that's going to be doing a business that's related to agentic things, they're going to have lots of startup money. So, yeah. So who you're targeting as a business, that matters sometimes when you're in domain investing.
Yeah. So this domain investor or SEO guy. So what allegedly he did wrong was when he picked up the name in the auctions, he parked it on a site that resembled apparently the prior site, but you go there now, you don't see anything. It's just a block page. But allegedly it was identical to the prior site owned by the prior registrant. And some SEO people do that just so they can get some continuity in Google's ranking. And, they try to preserve the links that way. But there are better ways. What you do is actually keep the same links on the site, but put in your own content. Never commit copyright infringement. Don't put other people's content on your site unless it's, fair game, like government stuff.
Yeah. I was going to say, like, very people often confuse difference between copyright and trademark, but when you're getting sort of targeted with a URP, and you have copyright material that's not the primary focus of UDRP, but it certainly can be seen as bad faith usage, right? If you're using copyrighted content, that's a pretty big no-no. So especially if it belongs to the complainant.
Yeah, well, I guess the complaint did acquire the copyright rights through the bankruptcy because I don't know that that was secured by the security agreement for the trademark. But maybe it is. I just haven't fully read it yet, so I'll check that out. But yeah, so those are our cases for today. What do you think, Arif? Did the panelists make two right decisions and two wrong decisions?
I don't know. Like these cases seemed like pretty caught like that. Even the UDRP should not have been used for a couple of them, right? It's more of a legal matter, especially the last one where it's like they didn't even have a trademark. That's panelists. They don't. I don't think they have the time, the expectation, or the capacity to do that kind of analysis. Whereas, like, it should be done, right? If you're going to make a judgment on such things, like, you want to make sure that that trademark is accurate. But sometimes they just take for granted that it might be, right? That's, again, also the panelists, how much do they get paid for a case? It's like they get paid maybe like 2 hours worth what they would get for a regular business client, right? So, I don't know. Just the whole way the whole UDRP process operates for me, it's questionable because it really, really favors people who have deep knowledge of the law, and usually 99 times out of 100, like that will favor the complainant. It's the resources are pretty limited. The rules are really complex. Like I sometimes I look at the rules and there's like 3 different sets of rules, right? There's the policy, there's the supplemental rules, there's this and that, and it's like I don't know. I just it can be pretty complicated, and that's why it's really good to just stay clear of this stuff. Like when in doubt, further examples of what what crosses the line and what doesn't. But it's just like the only resource that I know is you guys, this podcast, and maybe the ICA newsletter. And there's a couple of other lawyers out there who go into the forums. I know John Berryhill. He often goes into the forums, and he'll give thorough responses sometimes, and they're usually pretty funny as well. But it's a tough go for a lot of domain investors or domain holders, and I just wish there was more guys like you guys sharing information like that.
Well, yeah, thank you. So, so what would you have invested in Digital Seed if it was on an expired auction closeout for $10? Would you have picked that up?
Oh yeah, Digital Seed. I like that domain. Yeah, I don't think I would have paid. What was it, $802? You said probably wouldn't have paid that. Yeah, but like I'm just cheap like that, right? But yeah, if it was like $50 or whatever it is, I'd pick that up. I like that. Digital is a great keyword, right? And seat is not an obvious keyword that you would think, but it's a lot better than you'd initially think, because like seats, you often for software, right? You sell them to businesses, but they say like by the seat, right? Basically by the employee. So like let's say you bought licensing for Photoshop, right? And you have a big company, and you have like 20 people in your art department that you need it. Well, then it would be like a 20-seat license, they call it sometimes, right? Because it represents 20 employees, but it's like 20 seats. So sometimes those seats can be interchanged legally or depending on the terms. So seat is actually, and combined with digital, it's a good synergistic pair of words, I think.
So how much would you price that name for, like on a buy it now on GoDaddy?
Mid 4 figures. I don't think I'd put it higher than that. Like just as a generic, right? Not knowing there's any other user or whatever it is. Just I'd probably when I put it at 5 or at 10, it would be between 5 and it'd be 5 or 10 probably, right? I think to myself, because again, like when you're talking licensing of software on larger scales, that it's deeper pockets. So maybe probably 10K rather than 5K.
Yeah. All right. Great. So that's it.
Well, how about yourself?
Oh, I would have priced that name at 15,000.
Yeah. Oh, 15. Okay, so we're close.
Yeah. But I wish I had some like agentic intelligence sell for what, $150,000. That's pretty aspirational. But I'm sure there's other names that are 2 words that go for more. Didn't cognitive intelligence go for 300,000? But I think at the end the guy ended up paying 200,000 because he was on a payment plan.
Yeah, it was cognitive automation. I think it was. No, cognitive
automation. Yeah.
Yeah, I think it was. It was a buddy, Joseph. That was years ago though. But sometimes those one-offs, Yeah, well, I remember because it was during Domain Social Days. But so you'll always get those one-offs like that. But for me, like I don't know how agentic intelligence was presented. Was it just to buy it now? Because that's pretty gutsy to put a bid on that domain for like 150K. Because it's a great domain, but it's also it's long, right? And it's two of the best keywords possible, but you put them together, that's great synergy. But it's also long. Like so, in that case, I don't think it ever priced at 150K, right? Again, don't get me wrong, it's a fantastic domain, and easily into the 5 figures, but 150K, that's a great sell,
Yeah, it is. You have any great sales this year so far?
I'm having a really good year. For me, I don't do those like huge ones because most of my acquisitions are pretty low. But I've had 3, maybe even 4, 10 to 15K sales. Like I'm already in the black for the year. I sold a French.co name for 10K. I guess it's about a month ago now. I sold another domain just a couple of days ago, 5K. So yeah, I'm chipping along pretty well. I've been really busy with all my non-domain related stuff. All the family crazy businesses, with the mental health ×3 is going crazy. I'm back at work now too, so my ankle is slowly getting better. I'm out for a walk right now. It's beautiful out today. But I still have my cane. I don't use it every step, but every 3rd or 4th step when I'm doing hills or stairs. So I'm still. I got another really big thing that was I'm still kind of finishing up on that I'll talk about another date. But yeah, overall sales, I really can't complain at all. It's been a good year for me, and the average sales price has gone up. I'd say my volume is, if not the same, maybe even a touch lower than previous years in terms of numbers of sales, but my average sales price is just like rocketed up.
Well, that's amazing. Congratulations.
Yeah, and I've heard you've had a few sales too, right? You mentioned that.
I think I've had 4 or 5 sales so far this year, but they're $3,500 each. I got another one in the pipeline. The guy, it just hasn't paid yet, but he says, "Send me the invoice," and that was like a month ago. And he says, "Oh, hold it. I have to iron out some things." I guess he has to talk to his lawyer and get a trademark. Maybe he's worried about a pool company or something with a similar name. So we'll see.
That's amazing. I know in recent years before that, your sales were a little bit slower. So you're having your best year in a while.
Yeah, the .ca market picked up this year.
Well, congrats, man. I'm happy for you. That's good because I know you're holding on to something for a while, and it's that sounds like you're having and you don't have that many domains either, right? How many domains do you have now?
I'm less than 1,000, maybe around 600. I haven't even counted. I've just dropped so many. I think I've dropped over 5,000 in the past year.
Yeah. So if you've had like 5 sales in the mid lowish 4 figures, you're way profitable. You're doing pretty well with 600 to 1,000 domains.
Yeah.
So, especially since .ca's now they're still under $10, right, or about $10?
No, they're about $14 a year if you have a good discount on your account. 14
Okay.
Canadian.
Your sales, like the 4 or 5 of them you had this year so far, are they? Do you make them in Canadian dollars or US dollars? What was it?
4 of them were through GoDaddy.
Okay.
They were US dollars, but after you take out the GoDaddy commission, it's like getting in Canadian dollars. So.
Yeah, that's the one thing I like about the being in Canada is that your commission is 15 to 20%, but then the exchange rate coming back is like 30-something%. So for me, I like those, especially when I'm not in buying mode. I'm just in selling mode. It's like, oh, okay, I have like my war chest right now. I've never had this much money just disposable. I haven't bought in a while. This year I've really I slowed down because of my family stuff. I just haven't had the time. I'm back at work and my ankle and whatnot. So I'm just chomping at the bit to get back into buying more, but at the same time, I'm thinking this summer I'm going to just chill out, go for little walks. Come right now, it's beautiful out. Just chill out when I'm not working. As you guys know, Steamy passed away late last year. So like my 3 hours a day outside walking every single day and 4 hours sometimes, that's gone, right? So I'm trying to get myself a little bit back into it. I'm not ready to get another dog just yet, but it's something maybe in a year or so once the family stuff gets a little bit more settled. It'll never go away, but I still have some major things to get done, like sell my dad and stepmother's house, so that's going to be a big thing, cleaning up and some minor renovations and whatnot. So that's why I'm kind of holding off and making really big sort of decisions. But eventually, I got to get into the real decision of what do I want to do in my domain sort of life, right? Do I want to get full throttle, get back into doing live sessions, podcasts, conference again, or whatever it is, and increase my portfolio? Because I'm at 5,000 domains now, right? So that's not nothing either. Just maintaining that is, it's not too hard, but I get lazy when it comes to reviewing my prices and whatnot. So that's something I gotta dedicate some time to, and it's just I procrastinate a little bit too much for those. I like buying stuff, but when it comes to like pricing and all that stuff, it's just it's too boring for me. So we'll see where it goes. Either I start buying again in big numbers, or I sell off a bit in bigger numbers. We'll see which it happens. Have to be.
Have you used any AI tools to develop your sites? Any of them?
Zero at all. I do want to get into AI stuff, and even just basic build out, even without AI. I could, obviously at this point, it doesn't make sense to not do it without AI, or to do it without AI. But I'm still in that phase where I'm like, I just gotta just dedicate some time to getting organized, right? Like what domains? I do have a bunch of them. I probably have 300 domains, like in my inventory, where there's like a column of like, yeah, maybe build out, right? Like I have a certain amount where it's like definitely build out, and then other ones is maybe build out. And as I mentioned before, I'm not quite at retirement yet, but I'm thinking maybe next year, maybe February, March, starting a year of sabbatical. And that would take me to a point where after that, when I get back to work, I could go back to pre-retirement and work 2 days a week, which would be perfect, right? Like, given my job, I go out, I socialize, I get a little bit of revenue, I just pad my pension a little bit more. But, still only 2 days a week. And that gives me 5 days a week to get my portfolio back in order, but also do other projects that I want to get done. So we'll see. I'm at a midlife crisis, but I have no time to think about what to do. So I just procrastinate and put the decision to the next day.
Well, if you ever get bored, get a Perplexity account. They're free, and you can connect your GoDaddy account to your Perplexity account. They have a MCP connector built-in integration, and I don't know if it allows you to manage your portfolio or if it lets you build websites on GoDaddy. I don't know what the extent of it is because I don't have any domains on GoDaddy, so I haven't had a chance to try it out. But yeah, they do have a connector through Perplexity, and you can use Claude or Gemini through there. The free account lets you do 5 prompts a day, but like if you give it one good prompt, it can build a whole site in one prompt. So all that's possible. You just have to do some planning. So like, use other tools to do the planning, for example, Gemini, and try to figure out, like, for example, if I think that if this legal-now domain name wasn't built out, I think that there would have been a transfer in that decision, potentially. But because it was a Canadian-based business, the panel decided to deny the complaint. And I think that makes a difference sometimes. So we all have names that match trademarks, sometimes 4 or 5. And John Berryhill says, just build it out, put something there that's innocuous, not infringing any trademarks, but avoid that nuclear marshmallows thing where you haven't used the name, so we're going to assume you have bad faith, even though your contact information is correct and all the other stuff is correct, and there are plausible uses. So yeah, that's what I recommend. Build it out.
You said something interesting there. Do you feel there's ever a bias based on the country of respondent or even a complainant?
Yeah, absolutely. Yes.
Even when it would come to like Canada, like I know there's maybe some countries where it's like, okay, they always assume Yeah, there's always spammers and all that stuff where, there should not ever be bias anywhere. But, you can understand some places, there's some countries where 95% of the domains are used for scamming, whatever it is, but there's still 5%. That's the problem with the UDRP, is that there's always, by simple volume, there's a presumption of guilt of the domain holder, simply because it's like 95% of the time, it truly is, right? Like even for me, maybe not 95%, but probably like 90% of cases, I would say, yeah, this is real infringement. But that doesn't mean that the other 10% should be dismissed just because, 90% of the other ones are bad apples. And that's a big uphill battle. Again, it's we have a lot of problems as domain investors, and that's one big one I find.
John Bearhill ran an analysis through UDRP.tools and created a graph. And it looks like cases that are undefended get a transfer rate of 95%, but the ones that are defended with 3-member panel only get transferred 50% of the time. So your odds go up if it's defended and you have something to speak about.
That's a type of self-fulfilling data, I find, because just by default, if a defendant is going to spend $2,000 for the three sort of person panel, just by that very fact, that means, first of all, the respondent is going to put in a really good defense, but also it means that for $2,000, they think they have a strong defense. Doesn't mean that they have one, but just by that sort of reality, you're going to have just the type of case where the result will tend to be more favorable to the respondent than otherwise. So I don't think it's a real apples to oranges comparison.
Yeah, but there is a difference if it's a 1-member panel versus 3-member panel. That's for sure.
Yeah.
So
I guess it also matters who pays for the 3-member panel, right? If it's the complainant or the respondent.
Yeah, how often? I haven't seen too many complainants paying for 3-member panels. I think they usually go for 1-member because that way they get the people who are notorious for transferring domain names.
Yeah. Plus, I think more often than not, they're just going to assume, just by pure statistics, that the respondent won't even respond, right? What percentage of cases actually get a response? Is that a stat that we know?
I don't recall what that is. I don't remember seeing that.
I'm going to assume it's probably it's got to be less than half.
Probably less than 10%.
Yeah. Okay. Yeah, that 10% makes a little bit more sense. But even then, what percentage of those are actual decent responses where the person actually understands what they're supposed to put in there, right? Sometimes there's people willy-nilly put in the complainant side too. Sometimes you see complaints that just don't make any sense whatsoever. But more often than not, you see that on the respondent side. Not that it's the respondent's fault. It goes back to what I'm saying. It's just it's very overwhelming and confusing, all that information, unless you're listening to guys like you week over week.
Yeah, I'm not sure exactly, but I think if it's defended with a good response, maybe you have with one panelist a 40% chance of winning, with a 3-member panel 50%. But it also matters whether or not you hire a UDRP specialist. So I think that goes a long way. I think if you have a good specialist, you get a 90% denial, which is good.
Yeah, but again, that's it's going to cost you, right? And if you're in the right, you don't get that money doesn't come back to you, right? If you're a domain investor, right, and it's going to cost you $10,000, say $8,000 for the legal fees, and then $2,000 for the 3-member panel. That's $10K, right? In my case, how many of my domains are worth $10K? Not very many, right? Especially replacement value. Retail, maybe, yeah. But when it comes to the wholesale price, if I just drop it and take that $10,000 and use it to buy new domains, almost 100% of my domains, it would be more worthwhile for me to do that, and then also no time or energy involved. But at the other side of it, it's do you just let somebody take your stuff? Doesn't matter. Like some people, like you take my Kit Kat bar, and I'm going to take you to court, right? Not because it's a Kit Kat bar, but because you did something wrong. So it really depends how you perceive it, I guess.
Yeah, absolutely. Well, we do see cases where respondents who have a lot of transfers to their history lose more future cases. So it's a spiraling, like downward spiral.
Yeah, yeah. Well, I don't know. Overall, it's like there's the number of UDRP cases are going up, but I think also the number of findings where the complaint is denied, and also cases where findings of RDNH, I think that percentage is also going up. So, it's bad on one side but good on the other. And overall, I mean, there's a couple of thousand UDRP cases every year, maybe between 2 and 3. I don't know what the number is, but
There's over 10,000 UDRP cases last year overall.
Now 10,000.
Yes.
Oh, that's more than I thought it was. I thought it was closer to like 3. Wow. So that's so, but you can consider is what, like 160 million .coms and what, like 350 million overall domains. But again, it's like, you'd like to see that number be 0. And, again, admittedly, like there's a lot of people holding domains. I wouldn't even call them domain investors, because the people who, blatantly break the rules, trademark rules, like I don't really consider those people investors, because like they don't even understand the rules. So, but we're still lumped in the same category, right? Domain investors and cyber squatters, to me, it's 2 very different groups of people. But unfortunately, when it comes down to the law and the panelists, in most cases, they put us all in the same boat. So it's an uphill battle we're facing sometimes. Just that prejudice that's always going to be assumed. But if we get more and more cases where the RDNH finding is there, then maybe these lawyers who put in frivolous lawsuits will think twice before doing more. Because there's a lot of times, like I remember going back to this one gentleman, I can't remember, he's based in India or Pakistan. It's like 5-6 years ago. I remember it was in the Domain Academy, back when Saiga was running it, the forum. He was asking a couple questions, generic questions about legal stuff. And, especially back then, I was less informed than I am now. But I still, in the forums, I read pretty much everything that John Berryhill wrote, whatever it is. And, this fellow had like a 1-word, but generic word, repurpose CCTLD. Right, and but it was the name of a top 100 global brand, right? And the lawyer for this brand came after him, but with very fuzzy, non-precise languages, right? It's like, oh, my client thinks that you might be infringing on this and that, right? And
you're known as a reality TV star.
This guy didn't speak English very well. It wasn't his first language, obviously, and he didn't have resources for legal counsel. So I looked into it a bit. Then I started reading the original emails from the lawyers, first couple emails. There was no accusations there, but it was still really scary, right? Especially if it's your second language. It's like, it was really not illegal behavior, but I would certainly consider it highly unethical behavior, right? Because he was inferring things, using scary, well, it wasn't letterhead, but it was like, the signature was a law firm or whatever it is. And in the end, I helped this guy get, it wasn't get out of it. It's like, I took over the correspondence, and I let the lawyer kind of hang himself a little bit with things he said. I kept on, baiting him a bit with this and that, and then he never really said anything significant. So he'd come back every month or so, but so I decided to handle the domain. I go, oh, you didn't actually make any accusations last time, so I figured it was done. And then obviously the reply again was a little bit frustrated, and more. Then finally he said some things that he really shouldn't have. Again, nothing that any single one thing probably could have really got him disbarred or taken to court, whatever it is. But enough of an assortment of bad behavior that proved overall. And I just went over his head. And I went to the company itself. This was one of these IP lawyers, whatever it is. I guess I went to the company itself and I go, look, your lawyer is acting very unethically. I would appreciate it if you talk to this person. This is what's happened. I would appreciate if you talk to them and send an email to wasn't my client, but to the person I'm representing, to say you can use this domain as long as you're not like actually putting the logo of the company in or anything too obvious. Then yeah, there's nothing wrong with using it, and that's what happened in the end. And it's like, but again, like, how many people know enough to push back like that? There's just not enough people who do that. And so, yeah, anyways, I'm rambling. You guys shouldn't have put me up, but yeah, it's just sometimes these things, it's just the way we're set up is to fail sometimes when it comes to legal aspects of the domain industry as domain investors. And it shouldn't be, right? We should get our fair sort of saying things. It should be, you know, reasonable expectations on both sides, right? Again, I'm the first to say there's a lot of people who hold domains unethically, but again, there's also a lot of, well, I don't know if there's a lot, but there's enough IP lawyers out there who also use unethical scare tactics, I find at times. And, you know, people who don't know any better often fall for it and just hand over the domain. And that to me is wrong. And even worse is that I think, I don't know exactly how it works, but I think 9 times out of 10, these IP lawyers don't even consult on the one-on-one individual domains with their clients, right? They're given a monthly, not the reserve, what's the term it's used for legal fees? Retainer, yeah. So yeah, they're giving like a monthly retainer of X tens of thousands of dollars, and they just generate their own work, right? And sometimes it's just, they send these scary emails knowing that like 7 out of 10 of the people they send the email to will just hand over the domain because they don't know any better, or they don't want to go to court, or they don't, you know, that's what to me is what's frustrating, right? It's frustrating that people break the rules, people who really are cyber squatters, and it's frustrating that, you know, there's this bad behavior in you know, the legal industry where it's just it's self-fulfilling for these IP lawyers to just send out these willy-nilly unjustified emails to domain investors just because it works. But you know what happens is that they get paid for that, and so it's incentive for them to keep on continuing to do it. And that to me is where, you know, sometimes, yeah, it might not be worth it for you to fight back, but sometimes it just needs to be done just to put these guys in their place. Like when I helped this other guy, was it, I think it's 6 years ago now. I remember every couple of years I say, is it okay if I say the domain name? He always says yes, but then before I ever start talking about it, it's like 2 years later, and I want to get back to him and go, yeah. But I think one of these days I'll actually just ask him and go, okay, and then I'll come on here and actually say what the domain was. You guys are gonna freak. But it was 6 years ago. But like, it felt good to put this lawyer in his place. And it's like, no, you can't behave like that. I don't know if you ever got fired from the company because it's something that I think it should have happened. And, you know, if I had the resources when I was in the States, maybe I would fight to get this person disbarred. But, you know, it is what it is. You got to do little things sometimes, and it is what it is.
So WIPO reported for 2025, 6,282 domain name disputes for 2025. And UDRP.tools reports 8,236 UDRP cases from decisions from both WIPO and the forum. So we saw the check provider, and I think there's 2 other providers that are lesser known and lesser used. So yeah, there is probably easily over 10,000 cases in 2025.
Yeah, I tried using UDRP tools not too long ago, and it really didn't work for me. And I tried to register, and it didn't work either. That's Matt's site, right?
Yeah, you have to subscribe, and you have to.
Yeah, I couldn't even register. It was I didn't get the email. Yeah, I didn't get the email. So, yeah. And then it says you get 5 free searches per day. And the thing is, like, every time you touch anything on the page, it counts as 1. So it's not just a search. It's like anytime you just adjust something. Oh, another one. So it's like, yeah, why bother? I don't know, unfortunately, because it looks like it could be a really good tool. So it's probably one of those projects that I'm done. Yeah.
So I'm looking right now. I just I log in, like it shows 15 for today, and I can expand that to 100, so I can see the last 100 complaints decided. So there's actually a lot of complaints that are not decided at all, but rather filed and then dropped. So that represents a different, you know, number of cases. So as you know now, with I think WIPO, you can file for 5 names all at once in 1 complaint, and that'll get you 5 file complaints, and you can withdraw that, and you get $100. You just pay $100 for each one, or they give you a refund less $100 for each one.
Yeah, I think that was something you guys we talked about in the past, and it was one of those things that we're going to put like a pin in it and come back to and actually see if it's something that's being abused or not, right? Because if there's no abuse of it, then okay, whatever. But there's potential for heavy abuse, right? I mean, basically, it costs you $100 to get past privacy, right? And the whole point of privacy is that nobody can do it unless there's like a legal reason. And so, like in these cases where that happens, I'm curious, does the respondent ever get informed of such happenings, right? If they put it in and then, the second they get the information, they cancel it. Well, does the domain owner ever get known? Because I know sometimes when people, because I know when sometimes people put complaints into the registrar level sort of complaints, like oftentimes the domain owner won't even know about it, right? And that's a problem. I think you guys mentioned something about that a couple of weeks ago. I forget what the context was, but these sort of things are, ICANN needs to put some systems in place where there's certain rules for all these new little sort of ways where people. Oh yeah, well, you were talking about earlier on where the what was it? The registrar, gave over the information, right? Was it information, or they unlocked it, or what was at the beginning of the show?
When you file a complaint, the registrar will get notified, and then the registrar has to send the WHOIS information to the provider. And so that takes at least 2 days. In that time period, the domain is automatically locked. And so you can't transfer it. You can't change the DNS. So that's a problem for some people. And then if you have a monitoring service, you could see that your name is put on hold. And that tells you, oh, okay, there's a problem. And you might not see the complaint. You don't know what it's going on hold for, but at least you'll see it go on hold. But you need to have a monitoring service for that.
Yeah. And there's another situation too. I forget. It's another 4-letter acronym like RDRN or no, where it doesn't even have to be one like the WIPO or the forum. It could just be like a legal firm contacting the registrar for the information. I think what's the acronym? To look it up, but
I've been hard on something else, huh?
RDDS.
It's the first time I've been called a Nazi.
No, it's let me find it.
Raw registry RDAP response.
Hold on, let me see. Give me a second. It might take me a couple minutes to find it. Yeah, so I can't find it now. I know it's a 4-letter acronym, and the first and third letters are the same letter. I think it's R, like RNRD or RDRN, or let me see if I can pull up my keyboard if that refreshes my memory. RDRS, could it be that? Oh, I don't know. I'll come back to it next week. But it's like a rapid.
I don't know. I haven't seen that.
Okay. But anyhow, I'll remember it for next week. And we'll talk about it then, I guess. But yeah.
Thanks, Arif. This has been like a really good show for domain name law, show 264. So we'll be back next week. I'm not sure what time, but probably I think 6 p.m. actually works out better Eastern. So let's see if that works.
Beautiful day out here. Sorry if it got windy at the end, like the second half, but it's I'm assuming the same thing for Toronto. Must be really nice out today. It's just really beautiful warm, out today.
28 degrees.
Yeah, I couldn't not get out. It's like the first time I've actually put my shorts on and like enjoying the sunshine, and so hopefully everyone will have a good summer. We want to thank you guys again. Like you guys put a lot of work into these things. So I say it often, but it can't be said often enough. So you guys put on really good informative show. Those of you down below, put a little heart up for these guys. Even if their guys aren't here today, but for David, a little heart out for everybody. maybe not. I'll give a heart. But yeah, thanks again. And there we go, thumbs up and whatnot. But yeah, thanks again. And what you guys do is important. So I appreciate it.
Great. Thank you very much.